Good morning everyone. Now this is second lecture on of unit 4, which is distribution of the legislative power between union and center, and today's topic will be doctrine of pith and substance and colorable legislation. So let us understand what is this doctrine of pith and substance. Now, as firstly, the meaning of pith. What is the meaning of pith? It means the true nature or the essence of something. True nature or essence of something. And substance means the most important or essential part of something. Now, understanding this doctrine, so as it says, many a times a law passed by a legislature with respect to a matter within its legislative competence encroaches upon another matter outside its competence. This says, so basically it arises when there is a conflict between two or different subject matter of different list. So if a law is passed by a legislature with respect to a matter within its legislative competence, a law is passed by a legislature, but it encroaches upon another matter outside its competence. In such case, question arises in regard to the constitutionality of that law passed by the legislature, and it has to be determined. It can be determined by applying this doctrine of pith and substance. So therefore, the union and state legislature, they are made the supreme, and they should not encroach into each other's subjects. They have their own sphere. That the union legislature have its own sphere, the state legislature have its own sphere, where they are given the subject matter on which they can make laws. They should not encroach into their sphere reserved to other. So if a law is passed by one encroaches upon the field assigned to other, then the court will apply the doctrine of pith and substance. You will understand it more with the case law. By applying this doctrine, it will be determined that whether that legislature who made the law, was he competent to make it? Now, how would it determine? Through this doctrine of pith and substance, the true object of legislation or a statute which relates to the matter within the competence of that legislature which was enacted. It should be held to be intra vires, even though it might incidentally trench on the matters which are not within the competence of legislature. So what does it mean? It simply says, first thing which you have to understand, that it arises only when there is a conflict between two or different subject matter of different list. Now there can be circumstances in which subject matter of list 1 clashes with subject matter of list 2. So hence this doctrine is applied in this kind of situation. Now the main reason behind the adoption of this doctrine of pith substance, it is the power of legislature would be severely limited. If we it would be limited if every law were to be declared invalid on the ground that it has infringed its power. So basically this doctrine, it examines to check the true nature and character in order to ascertain that what list it falls. It is flexible It is used to determine whether the state is within its power to make statute, which involves a subject mentioned in the Union List of Constitution. Now moving on to the case. Here it is written, Pith means true nature, essence of something, and substance means the most important or essential part of something. Pith means knowing the true nature. True nature of what? Of the law made. And then substance, the most important and essential part of something. So this case is very important. Prafulla Kumar versus Bank of Khulna. Now what did the case say? In this case, validity of Bengal Money Lender Act. This was an act of 1946. Its validity, which limited through this act, it limited the amount and the rate of interest recoverable by a money lender on any loan. It was challenged on the ground that it was ultra vires of the Bengal legislature. And why it is ultra vire of? As it relates to promissory note. Now, and promissory note is a central subject. Again, let us understand it. So in this case, validity of Bengal Money Lender Act 1946, it was challenged. Now what was basically the act? It limited the amount and the rate of interest which was to be recoverable by a money lender, the one who money lender on any loan. So the amount and rate of interest recoverable by a money lender on any loan. So it limited the amount. It was challenged on the ground that it was ultra vire of Bengal legislature. That Bengal legislature cannot make it. Why? Because it relates to the promissory note. And promissory note is a central subject. Then how can a state legislature make on central subject? Now what did the Privy Council held? It said that Bengal Money Lender Act was in pith and substance a law in respect of money lending. And money lenders are state subject. And it was valid, even though it trenched incidentally on promissory note, but it was valid, the true nature. It understood the true nature. Here it is written, the Privy Council held that the Bengal Money Lender Act was in pith and substance a law in respect of money lending and money lender, a state subject. So this is how doctrine of pith and substance was applied in this case, and it is an important case, Prafulla Kumar versus Bank of Khulna in this doctrine. The next case is of State of Bombay versus F.N. Balsara. Even this is an important case. Now what happened in this case? Bombay Prohibition Act was challenged. Why it was challenged? Because it prohibited the sale and the possession of liquor in the state. Through this act, it prohibited sale of the liquor and the possession of a liquor in the state. Now it got challenged. This act got challenged on the ground that it incidentally encroached upon import and export of liquor across border. And import and export of liquor, it is a central subject. Then how can a state make a law on it? How can it prohibit the sale and possession in its state? But still, this act was held valid by the court. And it was felt that act was in pith and substance, fell under the state list. Though this act may impact the import of liquor, but it completely fell under the state list. Sorry, though it fell into under the central list, but was under. So this act was held valid by the court. As the pith and substance of this act, it fell under state list and not union list, though this act encroached upon the union power of legislation. So again, it depends on to case, and it has to be determined by the court, right? So it is also the state of Bombay versus FN Balsara is also an important case in it, and Prafulla Kumar versus Bank of Khulna was equally important. See, it is written that court held that act valid because the pith and substance of the act, it fell under the state list and not under the union list, though it encroached it. But it was under the pith and substance. Now we understood what is the meaning of pith and substance. Pith means true nature or essence of something, importance of something. How important it is, and the true nature of an act. Here what are we seeing? The true nature of an act made by the legislature, though it might encroach incidentally, but that cannot make the whole act wrong. So therefore this doctrine is extremely important. Sometimes it can happen, there can be conflict, and there can be conflict between two different subject matters, different list. In such case, if an act is made, what could be done? So this doctrine comes into picture. Moving on to colorable legislation. Let us understand what is it. It is very small, pith and substance, and colorable. Now what is colorable legislation? Now this is based on the doctrine of separation of power. And it is also based on the maxim that what cannot be done directly, it cannot also be done indirectly. What you can't do directly, you cannot do it indirectly. We will understand it through the cases. First, let us understand. Many times a legislature makes a law with respect to matter outside its legislative competence by giving to the legislation a different color so as to bring it within its competence. Now this line is extremely important and makes sense. It says that sometimes the legislature, they make such law which are outside their legislative competence, but they make it by giving to it a legislation a different color so as to bring it within its competence. They give it a different color. The color word is used here. In such a case, first thing over here to notice, law made with respect to matter outside its legislative competence. And the second thing, by giving it a different color so as to bring it within its competence. So that here you could understand the intention, what exactly the legislature is trying to do. But in this case, court applies the doctrine of colorable legislation, which determine again the true nature, character, or the real pith and substance of law. Three things: nature, character, or real pith and substance of law. And if after such investigation they found that pith and substance of law, it pertains to matter outside the legislative competence, then the law would be held invalid, and the law which they have made, it would not be protected. So basically what they do is they make a law in a different color Firstly, they are not, it is with respect to a matter outside their legislative competence. Then they make it that legislation is given a different color so that it might look that they are, it is within their competence. So in this case, in this doctrine, the court sees that they determine the true nature, character, and the real pith and substance of law. Then there's this case in K.C. Generai and Dev versus State of Orissa. Supreme Court have explained the meaning of doctrine of colorable legislation in this following term. Is it written? No, but I can tell you what is it about. K.C. Generai and Dev versus State of Orissa. So the Supreme Court said, if the Constitution distributes the legislative power amongst different legislative bodies, which have to act within their respective sphere, basically the idea which is conveyed by the expression is that although the legislation can make a law, like that, but the court has all the power to determine its nature through this colorable legislation doctrine, right? And then if the constitution of a state, it distributes the legislative power among different bodies which have to act within their respective sphere, marked out by a specific legislative entry, or if there are limitations on legislative authority. What are the limitations? It can be in shape of fundamental right. So questions do arise as to whether the legislature in a particular case has or has not, in respect to subject matter of the statute or in the method of enacting, transgress the limit of its constitutional power. Whether such legislation have transgressed the limit of its constitutional power. It was said in K.C. Generai. Then this last case is of State of Bihar versus Kameshwar Singh. In this case, Bihar Land Reform Act 1950, it was held void on the ground that though apparently it purported to lay down principle of determining compensation, but in reality it did not lay down any such principle, and therefore indirectly sought to deprive the petitioner of any compensation. So the court held it to be invalid and unconstitutional. So that's it about both of these cases and doctrine of colorable legislation. Hope it is understood to you. I can sum it up. Colorable legislation, it is based on the maxim that what cannot be done directly cannot also be done indirectly. This is what happened in this case, Kameshwar. It was held void on what ground? As it first purported to lay down principle for determining compensation, but in reality it did not give any such thing. But the act was made. So this doctrine of colorable legislation, it is applied when legislature does not have the right to make law upon a particular subject, but they try to do it indirectly. So that's it about colorable legislation and doctrine of pith and substance. Thank you. In the next one, we'll be doing about repugnancy